Good afternoon, everyone. My name is Professor Expelled, and I want to start off by welcoming you here, thanking you for coming, and also to reach the Ngunnawal and the Ngambri people, who are the traditional custodians on the land on which we are gathering today. I acknowledge that sovereignty was never ceded and pay respects to their elders, past, present, and emerging. And I think it's also important to reflect that in an event like this, which is a moot, which is essentially a mock hearing, a mock legal argument, that many different, diverse, rich forms of dispute resolution have occurred on these grounds in this land for centuries before the arrival of non-Indigenous Australians, and are still practiced and very much alive today. So today, thank you for coming. This is an exhibition moot. So this is a moot to let you know about what mooting is all about, and to watch some of ANU's best mooters in practice. No pressure. So today we are mooting a problem based on gender identity and sexuality that was actually co-authored by 3 ANU students. So we've got Madeline Castles, who is here, along with Javier Cross and Andrew Ray, co-authored this problem. And this problem, we ran the ANU, and this was all at Madeline's impetus, so I'm really glad that she is here today. ANU last year ran Australasia's first moot devoted to gender identity and sexuality, and we're hoping to run that again today. It's open to any Australian or New Zealand university, and it is run online. And so today, just for the purposes of this moot, we didn't want it to go on too long. We are just focusing on the allegations with respect to Ern Rui. So we can pretend for the purposes of this moot that the dispute between the school and Ms Aberdeen has been settled, and the appeal is only continuing with respect to the allegations in relation to Ern Rui. So we will follow after the moot, which we will probably finish before 4 o'clock. We then will have a question and answer session. So we've got a representative here from the LSS, and you've got me as the mooting director, and we've got all of our wonderful mooters here just to answer any question you have about mooting at ANU, how it works, why you want to do it, whether it's for you. And then, of course, after that, we have got drinks at the Fellows Pop-Up Bar. So we will get started.
So the full court of the Federal Court is now in session, and I'll take appearances. Thank you.
May it please the court, my name is L. Sundaramoorthy, and I appear here with my learned colleague L. McMiken. We act on behalf of the appellant in this case, Ern Rui. I will be speaking for 10 minutes, and my learned colleague will be speaking for a further 10 minutes.
Your Honours, my name is Jack O'Brien, and I appear as Senior Counsel for the respondent in this matter. My learned colleague, Ms Penelope Hahn, appears as Junior Counsel in this matter. I will be addressing appellant points 1, and Ms Hahn will be addressing appellant points 3 and 4.
Thank you. We'll hear from first counsel for the appellant. Thank you.
Your Honour, this dispute concerns the rights of non-binary individuals to express their gender orientation. The appellant in this case was subject to discriminatory practices while they were a student at Edinburgh Grammar, a private school owned by the Liberation Presbyterian Church of Australia. The appellant's gender identity was disclosed at a student and staff meeting without the appellant's consent. As a result of the school's non-discretion, the appellant was subject to name-calling, threats, and ridicule from both peers and teachers. The appellant faced no alternative but to leave the school and was subsequently diagnosed with depression and anxiety. There are 3 grounds of appeal in this dispute. The first ground of appeal asks whether or not the respondent can rely upon the religious exception contained in Section 38, subsection 3 of the Sex Discrimination Act 1994 Commonwealth, which I will hereby refer to as the Section 38 religious exception. And on that note, Your Honours, may we please dispense with formal citations?
Yes.
The second ground of appeal asks whether a tort for the invasion of a privacy exists in Australian law. And the third ground of appeal asks whether or not the respondent has breached the appellant's right to privacy, should such a right exist. I will be speaking to the first issue, while my learned colleague will be speaking to the second and third grounds of appeal. Turning now to the first ground of appeal concerning the Section 38 religious exception. We make 3 submissions in respect of this issue. First, we submit that Section 38 should be construed narrowly in accordance with principles of statutory interpretation. Second, we submit that the respondent's discriminatory actions are wholly unconnected to the doctrines, tenets, beliefs and teachings of the Liberation Presbyterian Church of Australia. And third, we submit that the respondent was not seeking to avoid injury to the religious susceptibilities of adherents to the Liberation Presbyterian Church of Australia.
Counsel, just before you move to your first submission, I think it would be helpful if you provided the court just with a just the background to Section 38 and this religious exemption. So why was it brought in, and exactly how does it operate?
Yes, Your Honour. According to the Section 38 religious exception, an educational institution may discriminate against persons on the basis of their gendered identity in certain circumstances. For present purposes, there are 2 conditions that are necessary to consider here. First, we must consider whether the respondent's discriminatory acts are connected to the doctrines, tenets, beliefs and teachings of a particular religion or creed. And second, we must consider whether or not the respondent's discriminatory conduct was in good faith. Sorry, I withdraw that statement. We must consider whether the respondent was in good faith seeking to avoid injury to adherents of the Liberation Presbyterian Church of Australia. Turning now to our first submission, in which we submit that as a matter of statutory construction, so the Section 38 religious exception should be construed narrowly. We submit that Section 38's context and purpose suggests that the provision should be read down. The object of the Sex Discrimination Act is, and I quote, to eliminate, so far as is possible, discrimination against persons on the grounds of their gender identity. The explanatory memorandum to this Act reiterates that the Act serves to foster a more inclusive society by prohibiting unlawful discrimination against the LGBTQIA+ community and promoting attitudinal change in Australia. And now,
Sorry, Councillor. And I accept your submissions with respect to the intent, the objective of the Sex Discrimination Act, but are there any principles to guide the court of how we interpret an exemption, an exception clause? So it's almost like this is being carved out. Can you assist the court with that question?
unfortunately, Your Honour, I'm unable to assist with the specific interpretation of an exception. However, we would note that in resolving statutory ambiguity, the court must have regard to a statutory provision's context and purpose. Support for this proposition can be found at paragraph 69 of the High Court's judgment in Project Blue Sky 1998, as well as section 15AA of the Acts Interpretation Act 2011, Commonwealth.
And Councillor, you may not be able to assist with this either, but just following up from the previous question, in the specific context of anti-discrimination law, have there been general statements made by various courts or tribunals interpreting anti-discrimination acts that guide the court on the principles of construction that apply, both to the major discrimination provisions and then to exemptions?
Yes, Your Honour. In particular, we would refer to the decision of the Victorian Supreme Court of Appeal in Christian Youth Camps Limited 2014. In that case, President Maxwell defined what the term injury means, and I will address those submissions about injury later on. Your Honour, moreover, in returning to our submissions, a narrow construction of Section 38 would conform to Australia's international obligations. Specifically, Article 26 of the International Covenant on Civil and Political Rights prescribes that the law must prohibit any discrimination on any ground, such as race, colour, sex or religion. Since Section 38 of the Sex Discrimination Act carves out an exception to anti-discrimination law, it should be given a limited operation.
And sorry to interrupt you again, Counsel, but what's the principle of interpretation? Is there a principle of interpretation where this court, being an Australian court, has to take notice of Australia's international law obligations?
Yes, Your Honour. We would submit that in interpreting statutes, Interpretations that are consistent with Australia's international obligations should prevail. Support for this proposition can be found at paragraph 26 of the High Court's decision in Minister of Immigration and TO 1995. Turning now to our second submission, that the respondents' discriminatory practices are wholly unconnected to the Liberation Presbyterian Church of Australia. Your Honours,
to take you back to your first submission that a narrow construction should be adopted, in what way would you seek to limit the scope of that exemption then? What's your substantive claim about what Section 38 is intended to cover?
Your Honour, to answer your question, I believe a counterfactual scenario might be of some assistance. So, for example, Section 38, subsection 3 might cover a situation in which the Liberation Presbyterian Church of Australia discriminated against a person on the basis of their same-sex relationship. And further to that, the Church has, in fact, made some clear views as to its oppositions on that type of relationship. So that would be one example which was, in fact, covered by Section 38 of the Sex Discrimination Act.
Before you move on, can I also ask, if we were to adopt a broader construction of that exemption, is your next submission contingent on us adopting a narrow construction, or could that argument succeed on a broad construction?
No, Your Honour, our argument can proceed on a broader construction. It is not fatal to our claim.
Thank you.
Your Honour, Section 38 prescribes, again, that in order for a discriminatory action to be lawful, it must be connected to the doctrines, tenets, beliefs or teachings of a particular religion or creed. We submit that in the current factual scenario, the requisite connection or causal nexus is absent. Although the Liberation Presbyterian Church of Australia has formalised its position on same-sex relationships, it has not made any express or implied pronouncements on non-binary students. Indeed, the fact that the school board, which is comprised of religious officials, agreed to a gender-blind casting in the school's senior production would suggest that the Church in fact accepted the expression of non-binary identities. Ultimately, we submit that the respondents' discriminatory practices are a result of the Reverend's personal prejudices as opposed to any distinct religious belief held by the Church.
Counsel, I'm just a little bit concerned about the logical consequences of your argument. If we accepted your argument, are we almost giving an indication to religious organisations around Australia to start adopting or espousing in their beliefs, in their practices, in their whatever sort of documents they have, that they, for example, are against the notion of gender being non-binary? I just wonder if you could allay my concerns with the policy implications of your argument.
Your Honour, unfortunately I can't assist with that matter. It would appear that an unintended consequence of finding in our favour would be that religious institutions would in fact pronounce views against non-binary students so that their views and their position are made explicit. But in this current matter, we must determine it according to the law before us, and policy considerations are generally beyond the purview of this court.
Sorry, Counsel, I'm going to follow up again. A more technical question. We have a limited agreed set of facts before us. Where does the onus of proof lie in terms of establishing that these actions do not conform with the tenets, and do we have a sufficient set of facts to determine that? May there well not be statements that are simply not before the court that establish, and wouldn't it be part of your onus of proof to actually lead those and to establish? I'm not convinced on the evidence before us that we actually know what the tenets of the church are with respect to gender.
In response to your question, I would make 2 points. We would submit that the onus is on the respondent to establish their doctrines, tenets, beliefs and teachings of the particular religion or creed. And in support of that proposition, rely upon paragraph 2 of the Victorian Supreme Court of Appeal's decision in Wesley Missions Council. To the second point, we would note that in order for a practice or belief to qualify as a religious practice or belief, it must have a source in some religious text or oral tradition regarded as authoritative within the religion itself.
Sorry, Councillor, I think you have about 1 minute remaining. So if you could just make your final points.
I hope that assists with that question.
Thank you, Councillor.
Your Honours, in sum, we make 3 points. We submit that the respondents cannot rely upon the religious exception contained in section 38 subsection 3 for 3 primary reasons. First, we submit that the section 38 exception should be construed narrowly and has limited scope. Second, we submit that the respondents' discriminatory actions are wholly unconnected to the doctrines, tenets, beliefs or teachings of the Liberation Presbyterian Church. And third and finally, we submit that the respondent was not in good faith seeking to avoid injury to the religious susceptibilities of the church. Thank you.
Thank you. We'll now hear from the Junior Counsel for the appellants, Mr. McMiken. Thank you when you're ready.
Thank you, Your Honours. I will now address the second and third grounds of appeal. Turning to the question of whether Justice Lee erred in ruling that a tort for invasion of privacy exists under Australian law, we make 3 submissions. The first is that it is open to this court to find that a tort of privacy exists under Australian law. There are 3 subparts to this. That previous decisions have opened the possibility of such a tort. Secondly, that previous decisions have indicated that the existing remedies in Australian law that protect individuals from breaches of privacy are insufficient, and that the policy argument in favour of a tort of privacy grows only stronger as technological innovation progresses. Thirdly, that development of such a tort is consistent with developments in other common law systems. Turning to the first subpart, that previous decisions have opened the possibility of such a tort. Your Honours, it is true that in 1937, the High Court in Victoria Park Racing and Taylor found that there was no tort for the invasion of privacy in Australia. However, the later decision of the High Court in ABC and Lanier has cast doubt on the continued applicability of this decision.
Council, sorry to jump straight in, but this is my immediate problem with this submission. It may be open to the High Court to declare such a tort, but we are not the High Court. And given that Victoria Racing exists, and given what you yourself have just said, that it established there was no tort of privacy, it doesn't matter what later cases of the High Court may have said in Obiter. It is only the High Court that can change that. We are bound by, are we not still, the decision in Victoria Racing?
Your Honour, it is not our submission that this court is open to defy clear High Court precedent. However, I would qualify that statement that I just made with points that were expressed by the High Court in ABC and Lanier. Whilst there was some discussion in Obiter about whether a tort of privacy exists, there was also, as crucial elements of the case, discussion about the way that Victoria Park Racing has been read. In fact, Justice Kirby indicated explicitly in his judgment that Victoria Park Racing has been read at too high a level, and that perhaps the orthodoxy that had ruled over the previous decades between that decision and Victoria Park Racing was too strong. And we submit that, therefore, it is open for this court to find that a tort of privacy does indeed exist and that it would not be in contravention of High Court authority. This is, however, limited, Your Honours, by making the point that it is true that in ABC and Lanier, there was no substantive finding that a tort of privacy existed. But we submit that that was in part due to the character of a respondent in that case. The case concerned the illegal filming of a Tasmanian meat processing plant operated by Lanier Game Meats Proprietary Limited. Justice Kirby indicated that he was unsure whether corporations are apt to enjoy a right to privacy, but he was, however, far more open to such a potential being opened in regards to natural persons, as is in this case. Similarly, Justice Squan of the District Court of Queensland in Gross and Purvis, in finding for a plaintiff who had been stalked, held that a tort of privacy should exist in Australia.
With all due respect to the District Court of Queensland, I believe that some of the other authority that you may point to later on also comes from the inferior courts. I mean that with no disrespect to said courts, is hardly a real groundswell from our superior courts on this question. Can you point us to any superior court discussion of the tort of privacy?
There is the decision of Nationwide News, Proprietary Limited and I.do, as well as from other jurisdictions from New Zealand, the United States and the United Kingdom that I'll address further in my submissions, Your Honour. But that's the extent of which I may assist you at this time. But just returning to the instance of the District Court of Queensland, Justice Scoyne's point was that the tort would be a natural development of the torts of infliction of duress and breach of confidence to meet modern challenges and modern standards. Turning to the second subpart of my submissions, that previous decisions have emphasised the policy reasons for such a tort. In Nationwide News, it was pointed out that outside specific circumstances, such as trespass, malicious prosecution, and defamation, that no tort exists purely to protect emotional harm arising from breaches of privacy, and that this leaves a gap in the existing law where individuals suffer distress from breaches of privacy, but are only able to obtain compensation if their circumstances fit within an existing category.
And sorry, Councillor, I know this doesn't arrive on the facts, but do you have any submissions with respect to if we did recognise that a tort of privacy exists, should it extend to corporations as well as natural persons, or are you making submissions on that point?
Your Honour, we submit that for the purposes of this case, our submissions are limited to that of the individual, and that would appear to be reinforced by the point made by Justice Kirby in ABC and Lanier that His Honour was sceptical about the application of a corporation having a right to privacy. And Your Honour, we submit that this gap in the judicial toolbox is becoming more apparent as corporations and Commonwealth organisations hold an increasingly detailed profile of our private lives, consistent with the submissions in the with the views of the Commonwealth Law Commission. We believe that the finding of a tort of privacy would ensure that these complex organisations are held accountable to the individuals whose information they hold and protect.
There are some rights under Commonwealth law for the protection of privacy, are there not, Council?
Yes, Your Honour, there are. However,
not sufficient.
It was the view of the Commonwealth Law Commission that a freestanding tort of privacy would enforce that right in a better way than that currently exists with haphazard pieces of legislation. Your Honour, as part of this subpart, we wish to rebut the view that the expansion of the breach of confidence would be sufficient to fulfil the role that we have submitted a tort of privacy would fulfil. We are aware that our learned friends will likely argue that the decision in Wilson and Ferguson nullifies our immediately prior submission. However, we submit that this authority cannot be relied upon to sustain such a counter submission. This case concerned the unauthorised distribution of sexually explicit images by an ex-partner, and the plaintiff in that case pursued a breach of confidence action. This action has three elements. The first, that confidential information is imparted. The second, that there are circumstances imposing an obligation of confidence. And third, that unauthorised use of such information harms the plaintiff. We submit that the second and third elements of this action severely limit its applicability.
Sorry to interrupt you, Council. Are you proposing a tort of privacy that is actionable per se?
Sorry, Your Honour.
Are you proposing that we establish a freestanding right to privacy with a tortious action that is actionable without demonstrating injury?
Your Honour, we are arguing that there is emotional distress as a basis of damage. Previously, the breach of confidence was only actionable upon economic loss, which is the main barrier to the plaintiff in this instance we submit.
All right, thank you for clarifying that.
Regarding the second element of the breach of confidence action, that of in circumstances imposing obligation of confidence, we submit that it's severely limited in its application in this instance. The Reverend did not have any interaction with the appellant on how the information regarding their non-binary gender identity was to be treated, nor was there any information given to the Reverend by the counsellor indicating that the appellant was not open about their non-binary identity. We submit in accordance with the views expressed by the Commonwealth Law Reform Commission and the New South Wales Law Reform Commission that forcing appellants to argue that imposition of confidence is clearly not the crux of discrimination issues and shouldn't be the driving inquiry that courts have to focus on in these actions. Regarding the third element, we submit that the Reverend's conduct was clearly wrongful, notwithstanding any potential economic damage that was given. This requirement reflects the commercial origin of the action, that it was calculated purely, as I said, on economic loss. But we submit that there is a fundamental value of privacy in an emotional sense that is breached when such breaches occur, per the New Zealand High Court's decision in Hocking and Runting as inspiration for that submission. Finally, Your Honours, to the final subpart. We submit that the development of such a tort is consistent with the developments in other jurisdictions. The United States, New Zealand and
Hang on, the United States has a constitutionally derived right to privacy. Surely it would be very problematic for us to adopt a framework with the absence of that constitutional underpinning.
Your Honour, if I request additional time to answer your question and to conclude my submissions.
Can we have additional 1 minute?
Your Honour, it is not our submission that we should be deriving constitutional rights discourse from the United States, merely that elements of the test espoused by Justice Lee, it does take substantively ideas from United States jurisprudence, as well as from the UK and the New Zealand jurisprudence. It is not necessary for our case to rely on constitutional rights discourse. Finally, Your Honour, our final ground of appeal of whether Justice Lee erred in determining whether that such a tort exists, Edinburgh Grammar breached the privacy of Ernbury. We submit that this ground of appeal is uncontentious, and that if Your Honours are with us on the case of the tort of privacy existing, that the Reverend's finding out of private information and the extensive disclosure of such facts mean that the test is satisfied. Thank you, Your Honours. That concludes my submissions.
Thank you, Mr. McMiken. We'll now hear for the first senior counsel for the respondent. Thank you. When you're ready, Mr. O'Brien.
Your Honours, I'll be addressing the first ground of appeal. That is whether the primary judge, Justice Lee, erred in her interpretation of the exemption in Section 38 of the Sex Discrimination Act, as it applied to the discrimination faced by Ern from Edinburgh Grammar. Your Honours, as my learned colleagues have accurately identified, Section 38 of the SDA is satisfied when 1, an act of discrimination was undertaken in line with Section 21 of the SDA. 2, that discrimination was undertaken by an educational institution that is conducted in accordance with the teachings of a particular religion. And 3, that discrimination was undertaken in good faith in order to avoid injury to the religious susceptibilities of adherents to that religion. Your Honours, we submit that Justice Lee did not own her finding that the discrimination undertaken by Edinburgh Grammar was consistent with these 3 findings.
Counsel, I think perhaps one of the strongest arguments put against your client was that there doesn't seem to be any evidence that this is a particular belief of your client. There's no evidence that your client has formed views about a gender identity and non-binary.
Your Honour, we refer to paragraph 2 and paragraph 19 of the Statement of Agreed Facts. In paragraph 2, the Archbishop of the Church of the Liberation Presbyterians identified that sexual intimacy is between a man and a woman, and that the Church does not affirm all ways of life. We feel that this implies that the Church does not accept those who do not fall within the categories of man and woman. Further, we refer to paragraph 19 of the Statement of Agreed Facts, in which the Reverend of Edinburgh Grammar, who is well versed in the teachings of the Church, identifies that Ern must identify as a boy and be referred to by staff and students as he, him, in accordance with the teachings of the Church.
I just wondered, with the purpose of the Sex Discrimination Act, whether we can refer, and this is specifically with your point to paragraph 19, of the teachings of and I do say this with all due respect, a mere reverend who is certainly not the head of the church, not in a position of great authority. I just wonder if we rely on his particular views or understandings, that this exception, this religious exemption, could become very, very wide. You know, anyone with any sort of even limited authority in the church can say something and then, you know, claim under the religious exemption clause.
Yeah, to build off that question, can an organisation within a church decide that it is going to extend the teachings of the church in that particular way? And is the Sex Discrimination Act exemption intended to give licence to organisations to do that?
Your Honours, I refer to OV and OW and Wesley Mission, in which the Victorian Supreme Court found that some elements within a particular church can hold a belief and others cannot hold that belief, but that belief will be sufficient for the purposes of Section 38, in which case we can find that whether the Reverend was referring to the whole church or merely a part of the church, that would still be sufficient to satisfy the criteria of Section 38.
And are those decisions binding on this court?
No, Your Honour, but they are influential.
To just before I let you move on, and I apologise, Council, if we were to accept your position that the organisation is allowed to determine for itself what its interpretation of teachings are, what are we to make of its conduct in allowing students of both male and female genders, if we're going to acknowledge the binary for the purposes of the exercise, in a school production? Is that something that would appear to be inconsistent with your client's self-professed position on gender?
Your Honour, even if we accept that the school was accepting of the non-discretionary gendering of their school play, which we submit in the facts, there was a lot of displeasure by both staff and students in relation to that. We identified that there was no non-binary characters, and the school still upholds that the male-female genders are the only genders that they recognise. And as such, we submit that that's not relevant to their disagreement with non-binary students.
Thank you for your assistance.
Sorry, I'm going to butt in as well. You are bound to get hammered on this, Council. You've submitted or made some submissions on the basis of OV, but the submissions that you're putting with respect to the tenets and beliefs of the church are in direct and obvious contradiction to the decision in Cobar. So why should we accept OV and not Cobar? Cobar clearly says that there must be clear evidence at a superior level before the tenets and beliefs of a church can be established. Indeed, Cobar took expert evidence on the matter.
Sorry, Your Honour, could you rephrase the question?
Cobar establishes that, an individual within, say, a school cannot simply decide what the tenets are. The tenets must be stated, explicit, have a documentary form, and must come from a superior source within the church. So that's what Cobar established.
Yes, Your Honour. And while we recognise that we are limited, as you previously acknowledged, on the statement of agreed facts, and there may be additional comments made by the church, which would be pertinent to this case, we do refer to paragraph 2, in which the Archbishop did make those statements in relation to the gender of students. And we identify the Archbishop as a senior counsel, as a senior member of the church that would be sufficient for the Cobar criteria. Your Honours, I now turn to the second criteria, in which we identify and we submit that the discrimination towards Ern was undertaken in good faith in accordance with the tenets and beliefs of the religion. Your Honours, we refer to paragraphs 10, paragraph 16 and paragraph 19 as evidence that the school was not willing to expel Ern, merely requested that they comply with the requirements of the religious teachings of the school. In particular, we identify in paragraph 16 that the Reverend said that Ern was welcome to stay so long as they complied with the requirements of the school's teaching. Your Honours, we submit that this is evidence that the school operated with good faith in accordance with the teachings of its beliefs. and not as identified in OB and OW, with excessive aggression or acts of discrimination beyond the confines of the doctrines of their faith.
Councillor, I wonder if you could assist me with something. Of course, on these particular facts, we are dealing with what the law would define as a child, so a person under the age of 18. And so I was wondering if you could assist the court on whether there is any jurisprudence which, how we interpret this religious exemption clause, especially with respect to children, or what submissions you would offer the court in that respect.
Your Honour, I'm afraid I'm unable to assist the court specifically with that question. I will note that Christian Youth Camps Limited did consider the impacts of children with Section 38 and its applications, and as far as we submit that there was no significant difference between the application of children and adults in that case. Your Honours, I will quickly turn to the matter addressed by the appellants in relation to the International Covenant on Civil and Political Rights and how it impacts the interpretation and construction of Section 38. We note that in the High Court, in Minister for Immigration and Ethnic Affairs and TO, only identified that the language of a treaty could be used to help the construction of a statute where the language of the legislation is susceptible of that construction. We note, as I believe Your Honours also noted, that Section 38 operates as an exception to discrimination, and we submit that therefore it cannot be constructed in line with Article 26 of the ICCPR, which requires that states do not allow any discrimination. This is a clear attempt at an exception to discrimination, where discrimination has been found, and we submit that therefore the ICCPR cannot be used to help construct that article.
Does it offer any guidance as to how narrowly or broadly that exception should be constructed?
Your Honour, we submit that the ICCPR cannot be used to construct the article at all, and we must rely on Australian domestic legislation instead to construct it. And in particular, we refer to Section 15AA of the Acts Interpretation Act, where we look at the purpose of the provision. And clearly we submit that the purpose of this provision was to form an exception where a school, in this case, has complied in good faith with the teachings of its beliefs. Your Honours, we therefore submit that the primary judge did not err in her finding that the Edinburgh Grammar, that Edinburgh Grammar did not commit an unlawful act.
Thank you, Mr. O'Brien. So now hear from the junior counsel for the respondent.
May it please the court. Your Honours, we make two submissions in response to our learned friend's submissions in respect of the appellant's tort of privacy claims. First, we submit that it is not open to this court to declare a tort of privacy. Second, we submit that even if such a tort does exist, that Edinburgh Grammar did not breach the tort in respect of Ern Brewery. Your Honours, turning your attention to our first submission, we make 2 points in respect to this submission. First, contrary to my learned friend's first point, we submit that previous decisions have only indicated the possibility of extending the equitable action for breach of confidence in respect of claims in this privacy arena, rather than developing a separate tort of privacy. Second, we submit that the development of the law in this manner is consistent with how the law has developed in other jurisdictions, such as the United Kingdom and the United States. Turning to this first point, Your Honours, my learned friend relied on the decisions of the High Court in ABC and Linnea and the District Court of Queensland's decision in Gross and Peppers to support his statement that Australian courts have opened the door to establishing a separate tort of privacy. However, Your Honours, a closer analysis of the obiter comments by the High Court in ABC and Linnea demonstrates an inclination of the court to expand the protections under an action for breach of equitable confidence, as opposed to establishing a separate tort of privacy. In particular, Your Honours, we would draw your attention to the obiter comments of Justices Gummow and Hain at paragraph 225 of ABC and Lenar. We note that those comments suggested that rather than to create a new tort or a separate tort of privacy, that privacy would be best protected through, and I quote, a menage of separate causes of action, including, for example, the confidential information and trade secrets in respect of corporations.
Counsel, even if we accepted what you were saying about the interpretation of Gummow and Hain's judgment, and I'm not at all sure that I do, but leaving that aside, explain to me how the breach of confidence could possibly do the job here. As your learned colleagues on the other side submitted, there must be a relationship of confidence. So it will not apply in every situation where there is potentially a breach of privacy.
Your Honours, it is not necessarily our submission that expanding the actions under a breach of confidence would be able to cover all circumstances in which a breach of privacy or breach of confidential information exists. Rather, it is our submission that perhaps it would be more prudent for the Australian courts and the Australian jurisdiction to follow the approach in the United Kingdom, whereby they protect privacy claims through overlapping causes of action through the courts with equitable breach of confidence actions, along with statutory protections that are afforded by legislation.
Counsel, you talk about this as being a more prudent course of action. What are the public policy concerns that you feel this court should be considering in determining whether or not to forge ahead with this path proposed by the appellants?
Your Honour, to answer that question, the main public policy concern we submit to have a separate tort of privacy would be that it would create a test that, and to quote Justices Gummow and Hain in ABC and Lenar, and Justice Edelman in a more recent case, Smethurst, and the Australian Federal Commissioner of Police, it would create a test that is of such high level and such high generality that it would blur the line between what was public information and what was considered private information. We submit that to create a test that would be of such a broad construction would indicate public policy concerns of that kind.
Counsel, isn't there plenty of jurisprudence, both within other jurisdictions and indeed under international human rights law, that domestic courts could draw on in formulating a test that was both appropriate and would avoid the sort of public policy concerns that you're espousing?
Your Honour, perhaps it would be open to the court to draw from other international decisions of the kind that you describe, but we submit that the appeal before Your Honours today concerns the formulation of the test by Justice Lee in this first claim, and we submit that that formulation, with all due respect to Justice Lee, is too broad and of that high level of generality that Justices Gummow, Hain, Edelman, and other members of the bench on the High Court have previously expressed hesitation towards. Your Honours, in summary of that first point, we submit that past decisions indicate that there has been continued judicial resistance to the development of a separate tort of privacy, which would inevitably be expressed at a high level of generality.
If we were to adopt the test that Justice Lee has proposed, and notwithstanding the concerns that you've brought to this court's attention, does your client have any submissions in response to those, or to defend an application brought on those terms?
Your Honour, I apologise. Would you mind clarifying the question?
Yes, that is definitely right for clarification. What I meant to say was, if we accept that a tort of privacy in the form that Justice Lee has proposed does exist, do you have any answer to that? Do your submissions rely on us not finding that there is such a tort?
Thank you for the clarification, Your Honour. And in answer to your question, no. We submit that if this court were to find that such a separate tort of privacy claim does exist, that in this case, our client has not breached that tort of privacy for two reasons. First, with respect, we dispute our learned friend's characterisation of the fact in issue here. We would turn Your Honour's attention to paragraph 15 of the Statement of Facts, which states that Ern sought confidential advice about how to communicate the fact that they were non-binary to school and classmates. To that end, we submit it was the advice to which a reasonable expectation of privacy, as formulated by Justice Lee, would attach, rather than the fact of Ern being non-binary. Second, we submit that public exposure of this fact, another element of Justice Lee's formulation, should not be offensive or objectionable to a reasonable person of ordinary sensibilities. And we think that this is evidenced by Ern's previous disclosure to a schoolmate. Does that answer Your Honour's question?
Yes, thank you for that assistance.
Your Honours, if I can assist you no further on that point, I'll briefly turn to the second point in our first submission, being that the development of the law such that it develops to create separate causes of action under the equitable notion of confidence is consistent with the development in other jurisdictions, such as in the United Kingdom.
So would it be open to us, counsel, to develop that cause of action in this case, and indeed to find that there had been a breach of confidence in this case?
Your Honour, we submit that the law in relation to privacy claims should continue to develop under these equitable notions, but that it would be an overextension of that principle to apply it to the circumstances before the court.
Which doesn't that then prove the point of the earlier question that there's no way that the breach of confidence action can fulfil the same function as the tort of privacy?
Yes, Your Honour, but we submit with respect that that same function could be achieved if supplemented by statutory protections like we see replicated in the United Kingdom.
Can I just come in on that? You know, you refer to statutory protection, so obviously in the United Kingdom they have the Human Rights Act. But surely isn't it one of the ideas of the common law that it is supposed to evolve? It is not set in stone. I mean, some of the images that have been given is, for example, I'll give you a minute to answer this question and to conclude your submissions. It's like a living tree. It is a living, growing instrument, and it should respond to new concerns. And privacy is certainly a concern that has really risen in the last decade in particular, with the increased use of technology, social media, surveillance, etc.
Yes, Your Honour, I do agree. We do agree with the notion that the common law should develop and should respond to technological and cultural changes in society. In respect of this submission, however, Your Honour, we submit that the most principled way of continuing to develop the law in a manner that is consistent with previous cases decided by superior courts in the Australian jurisdiction would be to follow that precedent, which has been to incrementally develop the law in relation to claims of privacy under these equitable notions of breach of confidence, and that is the most principled way for the court to move forward there. If I can be of no further assistance to Your Honours, that concludes my submissions.
Thank you, Ms. Han. So do we have some rebuttal? I think perhaps we'll have 2 minutes for rebuttal and 1 minute for surrebuttal. So when you're ready, appellants. Thank you.
Your Honour, in rebuttal, we make 3 points. First, we note that the respondents have stated that the Church has expressed its opposition to non-binary identities. The respondents have relied upon paragraph 2 of the Statement of Agreed Facts. However, paragraph 2 of the agreed facts only provides evidence of the Church's position of same-sex relationships, not non-binary identities. To suggest otherwise would erroneously conflate the concepts of sexuality and gender identity. Second, the respondents had pointed to paragraphs 10, 16, and 19 of the facts to demonstrate how the Reverend is acting in good faith. We accept and concede that the Reverend was acting in good faith. However, we submit that the respondent has failed to demonstrate how the appellant's expression of a non-binary identity would injure the Liberation Presbyterian Church of Australia. Ultimately, it is not clear how the continued enrolment of the appellant in Edinburgh Grammar would impact the religious sensitivities of adherents. Third, and finally, we note that the respondent has relied extensively upon UK jurisprudence to demonstrate how the breach of confidence action is sufficient. However, we note that in Australia, unlike in the UK, we do not have a Human Rights Act. Consequently, a fuller protection in the tort of privacy is required. Thank you, Your Honours.
Thank you.
We make one point in rebuttal. The appellant has noted that we did not identify the injury required under Section 38. We noted that the Ern's identity is against the teachings of the Church, as I have previously submitted. We note that injury, as identified by the Victorian Supreme Court in the Christian Youth Camps case, is not injury in the sense of physical pain. It is a reasonable expectation against the true beliefs that the, apologies, Your Honour, I withdraw that. It's against the doctrines to which the Church subscribes and the beliefs they hold. We feel that we have submitted and identified paragraphs 10, 16, and 19 in the Statement of Agreed Facts, which identify the Church's belief that Ern's identity is against the beliefs that they hold. And for that, Your Honours, we submit that there is sufficient injury to find that the discrimination was not unlawful under Section 38. That concludes my submission.
Thank you, Mr. O'Brien. Well, I think the considering the very complex and consequential legal arguments raised, we will reserve judgment on the outcome of the case. But what we'll just do now, thank you very much to our students, so Penelope Han, Jack O'Brien, Laksshini, Sundaramoorthy, and Lorenzo McMiken for a fabulous moot, and for just sort of want to point out what are the really, really good, what are the examples of great mooting here. And so one of them was really giving clear introductions. So each of the mooters stood up and said, you know, I've got 3 submissions, or I've got 2 submissions and 1 subpart, and they guided us through. And then even during the submissions, they said, I'm now moving to my second point, or if they were interrupted with a question, you know, I'm moving back to the point of. So they signposted, so it was really clear to tell where they were. And if they had time at the end, they gave a summary, but you don't always have time. I should say that the level of questioning today is not the level of questioning you would probably get in the novice moot. This would be the level of questioning you would get perhaps at the grand final or a grand final level. So there was quite heavy questioning today, but that's because we were genuinely, it is an interesting problem, and we were, but one of the skills of mooting is how well you answer a question. And so each of the mooters answered directly and succinctly, and then gave the authority. And when they didn't know the answer, they just said, I can't assist the court on that matter. And that's fine. There's nothing wrong with that. I think almost every mooter said that at least once. So there's, and sometimes it's perhaps the judge is thinking a bit laterally, or perhaps even, you know, I'll speak for myself, the judge is a little bit underinformed and asks a question that isn't highly relevant. And so that's all you have to say. So it's nothing to be scared of. I think the 4 mooters are obviously very good speakers. So they speak loudly, calmly, confidently, with the right level of decorum. So referring to us as Your Honours, referring to each other as my learned friend or counsel for the appellant. And it's not law and order, and it's not debating. Australian mooting, there's less theatricality, certainly than debating, and certainly than the American context. So don't feel that you can't be a mooter because you don't feel confident debating, or you know, you didn't do acting classes or anything like that. there was a lot of good depth of cases. So in particular, the discussion of Lena, I thought was really, really interesting. So there's obviously a deep looking at the judgments and analysing the judgments. Clarifying the questions from the bench, that's okay. A number of the mooters said, oh, I'm sorry, Your Excellency, can you clarify the question? And that's perfectly okay, because it's hard being a judge. And often the first time the question comes out of your mouth, it doesn't make a lot of sense. So it's better to seek clarification than trying to attempt to answer the question. And I really think what was great about the moot is that there was a conversation between the two teams. So the appellant tried to think about what the respondent might argue, try and preempt some of their arguments and almost rebut them. But then the respondent clarified the parts of the appellant's submissions that they agreed with. And that's really helpful for the court. So we know what's not in contention, but then of course directly responded to the elements of the appellant's argument that they didn't accept and disagreed with. So I might hand over to my fellow judges to see if they wanted to highlight some other examples of very good mooting practice. I think Kate's covered a lot of it.
Yes,
yeah, look, I would echo everything that Kate has said. I think this was a really nice little vignette, I guess, of what good mooting looks like. And I think from my perspective, one of the things that was a real strength for all the mooters was their knowledge of the law combined with a really authoritative but friendly and collegial style. So all of you had really nice speaking styles that allowed you to interact quite naturally with the judges. And we were interrupting you a fair bit. And I think the fact that you were able to conduct that response with a real sense of professionalism and courtesy, and you looked like you were having a good time. I hope you're having a good time. That is a sign of a very good mooter. Is one who can talk about the law, be taken off, your prepared dot points, answer the questions, and do it without the sense, or at least without the outward sense of losing control of your speech. And I think all of you did a very, very good job of giving the appearance of being in control of that conversation the whole time, even though we were interrupting you a fair bit. So I really like to call that out as a strength in this moot.
Thank you. Yeah, look, again, I agree with all the comments that have already been made. So thank you. Yeah, it was a great moot. It's true that we did intervene more for the purpose of the audience than you would often get in a moot. But yeah, not if you're talking about grand final sort of level. I suppose one extra comment I'd like to make, because it can be really difficult. That was a really good rebuttal. Rebuttals can be really difficult. Rebuttals have to be pithy, to the point, and strong in the points that they make. And you've got to be really careful about the points you select, because again, a bench can tie you up in a rebuttal, and it can really destroy and leave a bad last impression, for the whole bench. So yeah, rebuttals and surrebuttals are crucial and are very easy to mess up. And both of those, were done really well. Yeah, so that's an extra point to note in terms of the difficulties there. Look, one thing, and sometimes judges might disagree as well. I and some of the mooters will have heard me say this before, I do like a little bit of colour and performance in the presentation. So sometimes I think that Australian mooters are too monotonous. A little bit of light and shade in the voice, a few pauses for the sake of emphasis, even the occasional hand gesture, without going overboard, can sometimes add to a performance. So yeah, they would be just the extra comments that I would make, but fantastic, people, really enjoyed it.